Okay, welcome back to our last panel, but a great panel. It's called The Changing Tides of Regulation, Navigating New Regulatory Requirements and Guidance Around Cybersecurity and Ransomware. And I mentioned as we signed off in the last panel, this is going to be a terrific panel. Let me go through the panelists today because this is a good one. All right, so let's start with David Hirsch. He is the chief of the Crypto Assets and Cyber Unit in the SEC's Division of Enforcement. Prior to that, he served as counsel to SEC Commissioner Carolyn Crenshaw, primarily responsible for matters related to enforcement, along with digital assets and cyber. He authored the chapter on blockchain and information security in the Handbook of Blockchain Law and is joining us today from Virginia. Welcome, David.
Thank you very much. Great to be here.
Very pleased to welcome Aravind Swaminathan. He's a partner at Orrick. Aravind works with clients ranging from large public companies to startups to proactively plan for a data breach and cybersecurity crises. He's also now directed hundreds of cybersecurity incident and data breach investigations. Previously served as an AUSA and a computer hacking and intellectual property section attorney. Aravind's joining us today from Seattle. Welcome, Aravind.
Thanks, Bruce.
And very pleased to welcome Justin Webb. He is privacy counsel at Snap. Used to be called Snapchat for anybody who didn't follow that transition, but currently now called Snap. He handles privacy and cybersecurity incidents, as well as privacy and cybersecurity compliance at Snap. Prior to that, Justin was a data privacy and cybersecurity attorney and the chief information security officer at the law firm Godfrey and Kahn. And he is joining us today from Wisconsin. Welcome, Justin.
Thanks, Bruce. Glad to be here.
And finally, delighted to be rejoined by Erez Liebermann, a litigation partner at Debevoise and Plimpton and a member of the firm's data strategy and security group. Erez's practice focuses on advising major businesses on a wide range of complex and high-impact cyber incident response matters and on data-related regulatory requirements. He previously served as chief counsel of cybersecurity and privacy at Prudential. Before that, he spent 10 years as deputy chief of the criminal division of the U.S. Attorney's Office for the District of New Jersey, where he was also chief of the computer hacking and intellectual property section and national security cyber specialist. Erez is joining us today from New Jersey. Welcome.
Thank you, Bruce. Delighted to be here.
Let me turn it over to you, Erez. Thank you.
Thanks, Bruce. And again, really delighted to close out the day and delighted to see on our moderator panel here that so many people have come back. I suspect it's because we've got really three fantastic panelists that I get to moderate and delighted to be here for that. The day's been really talking about ransomware, and the discussion has been by a group of lawyers and attended largely by a group of lawyers. And the reason for that is in no small part because regulations around cybersecurity require that. There's also, of course, litigation that brings that to forefront. But that regulation is what we're here to talk about. That environment keeps changing. It's what makes me love this area so much. We're not dealing with 20-year-old laws that we're just reinterpreting for the 20th year in a row, but rather it's new laws every year. A couple new laws last year. I think we're going to see a bunch of new regulations this year. And that's what we're here to talk about. We've got an in-house counsel, outside counsel, and a regulator. I think that's a beautiful makeup for a panel to talk specifically about what the regulations are and how to handle them. We want to dive right in, but before, I want to give each of our panelists a quick chance to introduce themselves, just say hi, make sure their audio is working. Justin, why don't we start with you?
Hey, everybody. My name's Justin Webb. I'm privacy counsel at Snap. Like Bruce said, I work on cybersecurity and privacy incidents and general cybersecurity compliance, and I get to work with Snap's amazing security team. And just the regular disclaimer, all of the opinions that I share are mine and mine alone and not those of Snap.
Very good. Aravind?
Yep. Aravind Swaminathan, partner again here at Orrick. And just, I work with clients on the full vertical. So we do all the proactive work with clients to get them prepared for the inevitable. We do all the incident response work. And I also do all the litigation enforcement work for our clients. So it's a fully integrated practice where I often joke, I see clients on the first day that they walk in the door as clients of the firm and help them through all their crises, all their litigation and regulatory enforcement matters. And then I'm the last lawyer that they see as we get things resolved for them. So that's a little bit about my practice.
Sounds great. David, what about you?
Hi, Dave Hirsch, Chief of the Crypto Asset and Cyber Unit. As the name of the unit implies, we do both crypto regulatory enforcement, but we're also overseeing cybersecurity, two primary areas for registrants. So broker-dealers, investment advisors, exchanges, other folks who register with the SEC and are overseen by us, as well as issuers of securities who also have disclosure requirements around cybersecurity incidents. And like Justin, I should add, all my comments today are my own and do not necessarily reflect the ideas or views of the commission, the commissioners, or my fellow staff. Thank you.
Very good. And again, Erez Liebermann, delighted to be here. I'm at Debevoise, like Arvind's practice. We do from the beginning. Hopefully, we meet clients way before an incident happens. We help prepare and then take them through the cycle if it does happen, but ideally not. And then deal with regulatory issues, spend time in-house and government. So love all the sides of this. Really happy where things are now. It's very exciting with new matters. But let's dive in. 2022 seemed to have been the year of cyber regulatory proposals, even more so than other years, and every year has been chock full of them. But we had two new SEC regulations proposed regarding cyber, a new federal reporting law calling for reporting of cyber incidents in CERCIA. We had new proposals for New York DFS. Aravind, we could talk about all of them and just talk about the laws themselves for the good chunk of this, but maybe if you can give us a summary to lead us off, and then we can talk how companies should be thinking about these regs.
Yeah, I won't talk about the laws for the next hour because I think then the 250 people who have rejoined us, I think mostly because of your good looks, are going to leave us. So here's what I would say. I don't know how CERCIA is going to be pronounced, but let's just start there. So that's the Cyber Incident Reporting for Critical Infrastructure Act, which basically says that for covered entities, they're going to be required to report certain types of incidents to DHS within 72 hours. They also have, unsurprisingly, a ransomware component, which is if you make a ransomware payment and you're a covered entity, you have to report that within 24 hours of the time that you make the ransomware payment. That's sort of the meat of the regulation at the new law at bottom. The important things are twofold, in my view. One is that there are going to be regulations promulgated by DHS. The tail on that is really long. They have to propose them. The notice of proposed rulemaking is 24 months, and then the rules are in 18 months. So there's a really long tail on the mechanics of how this is all going to work and when the statute will go live. It's not clear that they're going to advance that or going to be slower and ask for more time, but it's a long tail. And so we're all sort of waiting on that one to see how that actually ends up coming to be. The NYDFS rule is not very dissimilar. It is basically, there are amendments proposed to the existing cybersecurity rule, which came out a number of years ago. And they, again, focus on things like ransomware payments. In other words, you're going to have to report if you are a covered entity under NYDFS's rules, you're going to have to report certain ransomware payments. What's interesting is they also have more prescriptive requirements for certain organizations that are covered entities to do things like, dealing with privileged accounts and also dealing with mandatory controls that they're going to have to do. Probably the one that's the most interesting coming out of NYDFS, and you'll see why I picked this order, is there's going to be much more enhancement around governance, right? Who do they have to report to? What are the requirements? Because I think it's a recognition that governance is actually fairly significant and fairly important. And so those are going to become prescriptive and we're going to require those. That gets you to the SEC rule, which also has a new reporting requirement if it's enacted. And that's basically 4 days after the determination that a cyber event is material, will you have to report that as a public disclosure. Right, so you'll have to do an 8K disclosing to the public that you've had an event 4 days after its material. Interestingly, the other place that the SEC has proposed rulemaking is around governance and control disclosures, which are actually really interesting and kind of dovetail with this approach. And so if you were to sort of like take these three as indicators for kind of where the ecosystem is going on the regulatory front, 2 or 3 things emerge as being thematically important. One, enhanced reporting requirements, right? Either to a regulator or to the public around specific types of events, particularly ransomware, right? Enhanced requirements to report payments made in context of ransomware, and then governance and emphasis on governance in the context of both the SEC rule and NYDFS. The last thing I'll just say, which is super interesting, I think, is that for the first time, DHS is going to have subpoena power and the ability to pursue enforcement actions where those reporting requirements are not met. That's importantly new because typically the way CISA worked was they didn't have that power and they weren't a regulatory enforcement agency and nobody looked at them that way. And one of the ways that they established their place in the ecosystem of being sort of the great collaborator, great cooperator, or the great helper for organizations that were under cyber attack was to say, we can't subpoena you, we have no enforcement powers. With the new statute, they're going to have those powers. How exactly they will use them and how exactly they'll come to be is left to be determined. But that's going to be a shift in how companies are going to think about cooperating with CISA and DHS more generally. And so I think that's going to have an impact on the ecosystem more broadly.
Great point, Aravind. And DOJ also with the cyber civil fraud also coming in from the False Claims Act. We were your friends at DOJ, and now we may be coming after you. How does that affect relationships?
Right.
Great point. Justin, any thoughts on these new regulations and what's kind of gotten the attention of in-house counsel on these?
Yeah, I mean, I think one thing that's gotten the attention is what Aravind said, which is that the requirements are a lot more prescriptive. So for a long time, the requirements were like establish a cybersecurity program and do, maybe a few things that are sort of around the margins of that. And now we're talking about like specific controls related to multi-factor authentication, how reporting should occur in the organization, who has responsibility, what the board's involvement in cybersecurity is. And so I think in some respects, that's a good thing. It's a forcing mechanism for companies to make sure that they've implemented those controls. At the same time, a lot of companies use the regulations as the ceiling for what they're going to do. As an outside counsel, you typically tell somebody the regulation should be the floor of what you're doing from a cybersecurity perspective, not the ceiling. And so I worry that some of the prescriptive requirements may actually end up being all that companies do. I think the other thing that still is yet to be seen on the SEC side is obviously there were a lot of public comments that were filed, and there's no exception for law enforcement. So if law enforcement asks you not to publicly disclose something related to the incident because there's an ongoing investigation, there's no exception for that. It's discussed in the regulations, but there's no final answer. And there's no exception either for sort of a similar thought, which is if disclosing the incident publicly would affect the incident response process. So if it would tip off an attacker, it could impact the way that you're responding to the incident, or it could let follow-on attacks occur. There's not an exception for that either. And I think what you see is the balancing of the value to the public of knowing about an incident over investigatory and law enforcement involvement and interaction. The last thing is, there's not really alignment with state data breach notification laws. And so the timeline is very compressed. And that's not necessarily a bad thing. I think what we're seeing, though, is that there's so many reporting requirements. And for some companies, they may span a lot of different regulatory agencies. And so it becomes extremely important to lay out a timeline of exactly every single regulatory reporting obligation you have based on the type of incident that you might have, and the thresholds and sort of reporting requirements so that you can kind of run down a list of who you need to notify. And that was a little easier because you had a little more time in the incident response process, given sort of like state data breach notification laws, which are typically, days, sometimes, 30 days, maybe even 45 days. So I think that sense of urgency makes it a little harder to make a lot of the sort of important decisions that you need to make at the beginning of an incident.
Yeah. One thing I'd say, Erez, that clients are now asking for, and I'm sure you've heard this as well, is we need to understand far in advance which regulations are going to be subject to and which lines of business will be subject to which regulations, right? And then one of the things we're doing for a lot of clients right now is to say, I know you haven't had an incident, but we need to build a work back so that we have all of those requirements laid out in some type of framework so you can understand when those little dominoes will fall and when you're going to be doing the notices. It's just too complicated to sit in a room in the middle of a crisis and say, okay, I got to do all these things. Where do all those pieces fit? It's much easier as you sit down, like if I were to sit down with Justin and say, okay, let's talk about the business, let's talk about where you are, let's talk about where the regulations apply, and build you a work back that says, here's all the notices are going to do. And then you can frame the work that has to get done in the crisis, right? And you know what pieces have to get done in those small windows. And so more than ever, because for all the reasons that Justin said, you've got to do much more prep around this. Because in the previous days, you could just be like, well, we'll figure it out when we get there. And it's usually like, Justin, if you have enough time, you don't have that time anymore. And these aren't going to be kind of this like typical early warning notices. There's going to be things you're going to have to do as a follow-on. And so it creates more workflow. And so the more you can do ahead of time, the better.
Great. Absolutely agreed. Dave, I want to make sure to turn to you. I know you're on the enforcement side, so we're not going to ask you specific on what the regs say, but what is it about the enforcement actions that kind of has led to this, and what can we learn from those enforcement actions about these? Because I want to then dive in. We'll start talking about risk assessments, materiality, some other questions from the actual regs.
Yeah, no, absolutely. I appreciate that. And you're right. I because I'm on the enforcement side and not the policy side, I'm limited in what I can say about things that at this stage remain in the proposal format. They have not yet been voted on. And so what they will actually say after, if they are adopted, when they are adopted, remains to be seen. And so I don't want to get out in front of that. But I think, taking one level of abstraction away from that, I mean, I think that the comments that Justin and Aravind both offered are telling, and the sorts of things I as a regulator am very happy to hear, in terms of the idea that clients are proactively thinking about, if something goes wrong, what's step 2, 3, and 4 that follows that. That I think that to the extent that you are waiting for an incident to decide what you're going to do in response to that incident, then it may already be too late. And I think that one of the things that our enforcement actions have focused on, and I'm thinking here about like Facebook and Yahoo, which were two of the larger cybersecurity related enforcement actions that the SEC has brought against public issuers, were both premised on the idea that the lag between when the incident occurred and when investors found out about it was simply too long. There was no justification for it. It left investors vulnerable and exposed to risk they weren't aware they were exposed to. In Yahoo's case, it led them to have their acquisition deal renegotiated down to the tune of hundreds of millions of dollars when their counterparty discovered it. And so I think the overarching idea is, regardless of whether it's a 4-day window or some other length of window, to provide a sense of urgency to issuers and to registrants that after an incident occurs that impacts their duty to disclose, that they are on the clock and be working expeditiously to try and get that information out to the relevant community that is requiring those disclosures, is entitled to those disclosures.
That sounds great, and that brings us to how we determine on those disclosures, right? So if we think through materiality on that, right? So the new cyber regulations, at least from New York DFS, the SEC, both have these disclosure requirements, and they're tied specifically to materiality, but neither of them really defines materiality. I heard a general counsel of a company not to be named who said that it's kind of like telling your kids that they have to be home in the evening, but not giving them a curfew, and then saying you'll figure out by when we punish you. And so a lot of us are feeling that and trying to figure that out based on things like that we're learning. Dave, I'm going to give you a chance, but Justin, maybe I start with you. Are you thinking through a matrix or figuring that out? And we'll open it to the panel as a whole. How do we think through that, and how are companies dealing with this upcoming disclosure requirement around materiality?
Yeah, I mean, I think we're like I'm thinking about it in the context of, I think you can look at the indicators, right? So you can look at previous enforcement actions and what's been determined to be material. The draft regulations themselves give examples of potential material cybersecurity incidents. And you can kind of think of the parade of horribles, ransomware incidents that affect key systems, large scale data breaches that involve lots of individuals, similar to the Yahoo incident that David was just talking about. And I think ultimately you've got to kind of go back to the case law on the SEC side that interprets materiality. And with this information, if you disclose the incident, be relevant to somebody who's making a decision about investing in a particular stock, or affect the total mix of information that's available to those individuals. I think in a practical sense, this is actually going to be very hard in some instances to make the determination. I kind of liken it to sort of a gut feeling, like I think you'll probably know it when you see it with respect to materiality. But I think there's going to be some hard calls there. And obviously the idea is to err on the side of caution. I think the challenge is there are so many downstream effects from notifying about a material cybersecurity incident. And so, you may, let's say you have an incident that involves your customers and has contractual sort of components to it. Once you file that material cybersecurity incident with the SEC, all of those customers are going to know about it, and you're going to have to manage that scenario. And so I think while it's not supposed to be part of that materiality determination, it may end up being part of it, just from a 30,000 foot level. So I think for the most part, the important part is go with your gut, follow the case law, and obviously seek the counsel of very smart lawyers like those on this panel.
Thanks, Justin. I think you're ultimately right, although I want to go to Dave next. If you call us, or any client calls us, and we gave, you got to go with your gut, might be our last call on that, even if it's a true statement. Dave, what can we glean from some of the cases and enforcement actions that might help us do that? And of course, Aravind, I'm coming to you after that for your thoughts.
Sure. So I think a couple cases that we brought recently are instructive, and I think the total number of cases we've brought, you can extrapolate some important information from too. And so as far as the total number of cases, I think it's fewer than 10. It's almost certainly fewer than 20 that we've brought in the cybersecurity realm, particularly as to publicly traded companies. And that is relative to tens of thousands of known breaches and incidents that have occurred across the country. And it is not that we don't value cybersecurity and don't demand people to make proper disclosures. I think part of that is a sort of a difficult story for us to tell because of the asymmetry in terms of the non-public nature of the investigations we undertake. So we don't talk about investigations we have open, and we don't mention those cases that we close without pursuing any enforcement action against. So I mean, I think you can, based on the few number of cases we brought, glean some information about like how we are trying to approach it. I think one of our overarching goals is to make sure that investors have all of the information that they need in order to make informed decisions about how to price for risk and about what the impact of a particular incident will have on the future prospects of the company. And that includes how customers would react to knowledge of the event. But I think we're also sensitive to if companies are doing their best to try and manage for risk on the front end and to try and be fulsome in their analysis of what has occurred and the impact it's likely to have on the business. All of these incidents fundamentally involve a business that has been victimized by an outside party, and we are sensitive to not wanting to re-victimize an entity that is doing its very best and investing appropriately in cybersecurity and cybersecurity response. And so there are levers that we are considering that aren't necessarily super publicly known or easy for us to articulate in the abstract, absent some actual public statement relating to a particular enforcement action we brought. But so bring it back down to concrete examples. So I think the First American financial case that we brought summer of 2021 is instructive. That was one where there was a problem in the company about what the CISO knew and what the folks who were out making public disclosures knew, and a mismatch between those data sets. And so the CISO was aware of a vulnerability that was, significant to the enterprise and was taking some internal steps to try and address it, but it was over the course of multiple months and the vulnerability remained. A journalist discovered that vulnerability right before Memorial Day weekend and notified the executives of the company and said, I'll give you some time to patch the hole, but I'm going public with this. That's my job as a reporter. And the executives scrambled and came out and made some disclosures saying, we just became aware of this, and they were not accurate in their description of the scope of the vulnerability and how well they had responded when they were informed of it. And we ended up bringing an enforcement action against them. And that was, I think, hopefully will be instructive to industry to say, make sure that you are not sequestering CISO in the basement as just a technical arm that doesn't have an important role to play throughout the enterprise, that you need your general counsel. And we don't prescribe a lot of how a company is supposed to respond to cybersecurity risk and how they're supposed to disclose, because we regulate such a broad range of enterprises and industries. It would be really hard for us to tick off a list and say, you must do these 8 things and then you're good, because there's just so much variation among the people we regulate. And so instead we lay out a bunch of principles and kind of broad expectations that each company should then interpret and address based on their own individual risk tolerance and risk exposure. And so here we just felt like, hopefully other companies, I believe that case is a good example of other companies going forward should be making sure that they have open lines of communication with the cybersecurity professionals they're employing, so that when it comes time to make a disclosure, they're armed with all of the information that's relevant, and they can make sure they're making accurate disclosures to their investors. And then very quickly, the Pearson matter that same summer, that involved an education company. They also suffered a breach. They came out and made some inaccurate statements about how quickly they had responded to the breach and how impactful the breach was. And then later the truth came out that, a number of tens of thousands, hundreds of thousands of students, social security numbers and birth dates had been exposed. There was significant PII exposure. They'd been aware of the vulnerability earlier than they had let on. And we brought an enforcement action there. And I think, again, the idea is, be fulsome in your disclosures. If you've had an incident that's going to significantly impact your business, your customers' confidence in you as a steward of their information and their business going forward, that's something that your investors are going to want to know about, and something that you should be ready to disclose, and something you should have a plan for. If you suffer this type of incident, who needs to know about it within the organization, and then how do you make that information public in an expeditious way?
Very good. Aravind, we heard a lot there, and not the least of which, how do you escalate? How do we make sure companies are thinking about this correctly? And then how do we reach that right, I agree with Justin, that right gut decision, because there's no clear science around this. How are you working through that?
So that's a great point. And I think David sort of indicated. So I think start with the back first, which is, we'll sit in a room with a client and try to make the best decision around material or judgment around materiality that we possibly can. And Justin's not wrong. It's kind of like sometimes you do know it when you see it, but sometimes you don't. But those edge cases are always going to exist. And at the end of the day, for the reasons I'm about to explain, I'm always happy if we've gone through that process and made that judgment to sit opposite David and make my case for why it is or is not material. Right. And there's some things I cannot control. I cannot control how the stock market is going to react to something. I can make my best guess, but I can't control it. And we've seen all sorts of things in terms of like stock prices change or not change when an event's disclosed. So I'm always happy to have that argument opposite someone like David if we have to, and try to figure out whether he's right or maybe we just disagree. But, and this is the big but, where we're going to get caught every day of the week is when we don't have a process. And so I start with, okay, we have to have a way of evaluating these with a set of objective criteria and raising the issues, right, to the right people to make those judgment calls and to be in a position to make those judgment calls, because that's where you'll get caught. And I can't comment on a lot of the actions that David talked about because I'm involved in most of them. So I will say it as a general principle, right? You have to start with every incident has to be assessed for the level of severity. The more objective criteria you can attach to that severity assessment, the better, right? So that you're not making judgment calls all along the way, but there are some things that are a little bit more black and white, right, from a severity assessment perspective. You take that severity assessment, and then when you get to a certain threshold, they're getting escalated, right? They're getting escalated to the GC, to the disclosures committee, to whomever, so that the people who have the ability to make judgment calls about materiality are in the room with all of the information that they need making that call. Right. So what we find, what we oftentimes say is materiality is like sort of like we can all argue about it, we can all agree, we can all disagree on what that is, but what we can all agree on, uniformly is to have a process. And the process we build for clients is to say, every incident goes into a matrix with objective criteria that helps you make a judgment call. It's a tool, helps you make a judgment call about the severity of an incident. You use that, you apply your judgment to that, you escalate, because it dictates that you escalate in certain ways. So if you're at a SEV 3 or SEV 4, it's going up. SEV 2, not. SEV 1, never, right? And as facts change, you can move from SEV 2 to SEV 3 or SEV 3 to SEV 4. It gets escalated. The disclosures committee has its process to review the facts that it needs to understand, consult with counsel, do all those things, and make a call about materiality. So rather than, what we've told clients is, rather than try to figure out what is or what is not material in the abstract, which is basically impossible, work and focus on whether you have a process so that when incidents get identified, they go through this gauntlet to get to a point where, you know, I'm sitting down with the in-house counsel, the security people, and whomever, and having a really fulsome discussion. We're making a judgment call and we're going for it, right? And then on the backside, if I have to have an argument with Dave, fine. Like, we'll have an argument. That's what lawyers do, right? But Dave is going to hammer me 100 times if I don't have a process. That's like the easy win. If you don't have a process, it's like, look, you don't have a process. You guys like relegated the CISO to the basement and nobody knew. Like, that's the slam dunk. And like, that's just, you know, it's just easy pickings, I think, for Dave. I don't want to speak for you, Dave, but that's what I would guess.
Well, I can't agree more. I think having that matrix that you're talking about, and I love the idea of having hard factors and soft factors, right? These are triggers that you definitely would identify material. These are ones that might, depending on how they go, and not just on whether it would affect the stock price, right? On reputational, operational, regulatory, financial. These are all different things that have these factors go into that matrix. And then, yeah, we use it to arm wrestle Dave at the end of the day. I love that. But one way to arrive at some understanding of that, and I think that feeds really into governance. And on this, I think the regulators, Dave, you guys and others, have done a correct job, which is, in order to govern correctly, you need to understand your risks. And that requires a risk assessment. It starts with that. The regulations factor that in. New York DFS started with that in 2017. Both sets of SEC regulations really talk about that. Justin, you're in-house. How are you guys thinking about that risk assessment process that'll help you with governance, help you with the board, and help you align with these regulations?
Yeah, I mean, I think you mentioned that the risk assessment process is talked about in the DFS regulations. It's in both of the SEC proposed rules. And I think there are roadmaps in all of those that talk about what the risk assessment process should look like. And I think ultimately what you want is some objective analysis of the risks in your organization, to your information systems, and to the data that you have. An analysis of what kind of mitigating controls that you have in place to potentially address those risks, and then a process by which those are escalated within the organization to management and to the board to analyze those risks and to put in place resources to address risks that you think are the highest that need to be addressed. And also, I think a lot of people glaze over when they think about risk assessments. It's not the sexy thing to do. People don't like doing them, but they're also a snapshot in time. And so I think something that I've seen in practice prior to going in-house was that if you ask somebody if they did a risk assessment, they'll say, yes, but I did it in 2017 and I never did it again. And so obviously it's a snapshot in time. It needs to continue to be done. And it needs to continue to be escalated in the organization. And I think for some security professionals and risk professionals, the framing of it should be, look, this is a way to get resources for the things that I want to get done in the organization too, right? So if you identify risks and you escalate them, it's sort of, again, the parade of horribles that may get you the resources to fix those things. And obviously, if we get into the nuts and bolts of it, there are frameworks that you can use. So there's the FFIEC framework, there's the NIST CSF, there's also, I think, the CRI, and a lot of those are a little bit or a lot bit focused towards financial institutions and critical infrastructure. And so I think the other sort of like important message about risk assessments is they're very organization dependent, industry and vertical dependent, and data dependent. So a one size fits all approach works in some respects, but you've got to be able to sort of talk about the specific risks of your organization based on the type of organization that you are, be able to articulate those things in a way that are also digestible by executives and by the board. And so if you put in front of them the NIST CSF with a bunch of check marks and information, they're not going to understand what you have. So you've got to take that, digest it, and put it in a format that you can actually sort of talk about risks in a meaningful way.
Erez, here's what I think the challenge on this is. So I agree with everything Justin said, but here's I think where the challenge is. What Justin's describing and what the regulations contemplate is like the monolithic risk assessment, which everybody hates, where you come in and as an enterprise, you're like, start from the beginning and look at all the things. And you come out at the end, you're like, this is your risk assessment, which frankly is not actually that useful for two fundamental reasons. One of which Justin already hit on, which is like, it's a point in time. The second is it's a monolithic risk assessment. So you're not looking at specific areas of risk and doing risk assessments there that are actually indexed to those business operations or business functions. You're just kind of hitting everything with the same giant sledgehammer. And here's the other problem. Nobody's doing the most advanced companies that are looking at risk aren't doing monolithic risk assessments anymore because they know that they're broken. They're doing dynamic, evolving, embedded risk assessments, which don't look like the monolithic risk assessment. And so how we get into a situation where we're having a conversation with a regulator, they're going to say, well, where's your risk assessment? And if you're trying to explain to them how you've done these more embedded dynamic risk assessments, they're like, I don't understand that. I don't know what that is. And there's not the same type of paper trail that comes out of it because it's not this monolith. And in fact, it is, Justin, I don't know what your experience is, but like that's actually the best practice, right? From a security perspective, that's actually where companies should be going, because it's not point in time, because it's much more specific and indexed to what the business operations are, and that element of being dynamic are really critical. So where I think we as the lawyers are going to have a really big challenge is translating that paradigm shift for the security ops people and the risk people to doing these dynamic risk assessments. I'm not even going to call them assessments anymore, but dynamically assessing risk, right? How are we going to translate that into a piece of paper, so to speak, for a regulator to understand? That's the hard part. That's the really hard part, because that's where these regulations, great that they're, like to your point, like great that they're changing, we're getting new ones, but this one's already outdated. Like this whole process is already outdated and we're going to be stuck with it.
Yeah, I mean, I would completely agree with that. And I think like this is the risk assessment of like the Defense Department and like 2000s like IT. It's not the risk assessment that engineering first and technology first companies do. Mm-hmm. And so I think that is something that I continue to worry about, is how do you present what you believe is the best methodology for addressing risk in a compartmentalized way and in a real-time way, against sort of some of these sort of, I hate to say, but like old school frameworks for assessing risk.
And the challenge is like the dashboard, right? Like how do you feed it all into a way that's actually visible? So that's the other problem, is like on the governance side, right? Justin, is like how you feed this into some dashboard view so that the executives are actually the ones that are responsible for accepting or assessing the risk or evaluating the risk, can actually see them in real time. That's the challenge. That's not a good output for the regulator either. And like, I just want to double down on this. Technology first companies that are looking at this, who have dynamically evolving environments, right, which are changing regularly, if they're embedding risk into that process, it's much better. And so this gets back to the point we made, you and I were talking about it before, Justin, which is like, you got to document a process. And at least if you have explained somewhere in your policies or your documentation that you have a dynamic risk process and what it looks like and how you do it and who's responsible and who accepts risk and who doesn't accept risk, that's at least the way we've started this process of what we're going to produce if we're ever asked about a risk assessment.
Yeah, I mean, I would just say like,
I want to get to Dave. So give me let me get to Dave on this for a second, because we want to hear from the regulator. And let me just tee up Dave for a second, because I suspect that there's another side to this, not technology first companies like Snap and Aravind, like you're talking about, but those who aren't doing the old monolithic approach and aren't doing the new approach. They're doing nothing, and that's a real problem. And I can understand therefore where the regulators are coming from. So Dave, I got your back on that at least. Let me give you a rebuttal here on what you're seeing and what companies really need to do who are not kind of where Snap seems to be, which is awesome.
No, I appreciate that. So happy to respond to Justin and Aravind on the specifics. And I think it's an interesting point. And I think that when we as regulators are doing our job best, we are demanding from companies, expecting from companies that they are doing what they need to do to protect investors and protect their customers' information. And if that changes because the environment for their operating changes or based on a development of newer best practices, like the people who I have the privilege to supervise are smart, flexible, adaptable, and learning on the fly, and I think are willing to hear that there's a different narrative than the one that has already always been told. But I think that also needs to be documented, also needs to be verifiable. So before we get to that, though, I mean, I think an example of like more significant failures to do anything that would be expected of you. We've seen that recently in the Reg SID framework. I think we brought some enforcement actions against JP Morgan, UPS, and TradeStation regarding their ability to engage in identity theft and AML protections. And at varying levels, the three of them took different size penalties based in part on the size of the violations, the size of the enterprise that was committing the violations, and how long those things have been going on. But between the three of them, there were some significant failures to design and tailor programs that were relevant to the risks that enterprise actually experienced. Everything from just reiterating all of the risks that were included in an SID risk alert, even though 15 out of 20 of those are things that the company did not engage in and could never be exposed to, like an online broker talking about people showing up at their offices that didn't exist, not having the correct physical identification. Like you can put that in your risk profile or your processes that we have to control for this, but if that's not a risk you're ever going to encounter, you're not doing a very good job of tailoring the protections or the processes you're building to the risks you're actually experiencing. And so I think hopefully those actions help to emphasize the need to be specific, dynamic, proactive, and to tailor the things you are trying to do to protect against cybersecurity risks to the actual lived experience of that enterprise. And that lived experience will change, and your processes should change with it, ideally. I don't think we expect that change to be real time, but we do expect it to be dynamic. We do expect to reflect what the CISOs and what the general counsel's office and what the executives are thinking about and seeing in their business, and making sure that their processes are adapted. And so for Justin and Aravind, what you described makes a ton of sense as described, but I think you're both also correct that you have to think deeply about how you document that, how you're able to communicate that. Like if a regulator comes in and says, well, now there's this huge mess, like what happened? And you can say, well, we had 40% of our most mission critical operations were in this area. And we kept seeing these types of hazards or threats proliferating. And so we decided we were going to devote a significant amount of our resources to iterating processes to try and protect against those threats. And here's the data we had incoming, and here's what we were doing in response. Like, I think that is a story that can be told and that shows a high degree of corporate responsibility. But if you have an incident and you come to us and say, we were dynamically acting in real time, but you can't articulate it further, it's really hard for us to be able to verify and be sure that like what you're describing to us is something that we can then take back to our client, which is a 5-person commission, and say something bad happened, but something bad can happen no matter how good your cybersecurity is. And here they're blameless, or it doesn't bear taking an enforcement action because their efforts were credible, because their processes were clear, and because they devoted resources to trying to update as their experiences developed.
Well, thanks, Dave. I think that the risk assessment really is critical. I do want to do one shout out. Justin, you mentioned the CRI, that's the Cyber Risk Institute profile. This is a shout out, has nothing to do with me or anyone else. It's a free tool. Every time I mention this, people ask me what it is. It's free. It's on the cyberriskinstitute.com. It's called the Cyber Profile. It maps controls to cyber regulations. So just an unbelievable tool for lawyers and compliance professionals to start reviewing how to get involved and where it is that these regulations are hammering home the controls. And did I mention free? So I highly recommend going and looking at that and using that tool. We only have a few minutes left, and so I'm going to tee it up as Aravind, Dave, and then Justin, because we're going to talk about the board. And we talked about risk assessments, materiality, and these regulations, some might argue, I argue, are sending the board a little bit too much into management role as opposed to oversight, but they are what they are. They're coming out. It's going to be a little more of that for sure. Aravind, how are you working with the boards to get these risk assessments and not give them a NIST score, which there's no way they get, and to have them provide that oversight or management if they need to based on these new regulations?
So look, I mean, experience is key, right? And the thing that we're sort of thinking about with clients is as much as there's now an emphasis on having board members who have specialized training experience in cyber, what we're sort of looking at is to say, let's not over-rotate on that. Let's think about having a well-rounded set of board members who can look at risk the way they've traditionally looked at risk, because cyber is just another area of risk and boards can do that. And have people who've got experience in technology and information and data and in cyber, but not necessarily singly threaded on that. The reason for that largely is what we've seen in companies that have large data breaches, where they have somebody who's got really deep expertise on one specific area, they become a jury of one. And everybody starts deferring to them, and the board is not then doing what we really want the board to do, which is bring all of their different viewpoints onto a problem and assess risk as a collective, right? And manage that risk as a collective. And so to the point that you're making, Erez, I think what we're trying to do is educate our board members, right? And bring those that don't have this technical expertise higher up, right? Emphasize the ones that do have technical expertise if we can address some other issues and sort of build that well-rounded entity, right? Which is the board, not a board member, and help them better be able to think about cyber risk and manage all the things that come along with it.
Dave, what do you think from the regulatory perspective? Where have you seen boards just not have enough and it's affected what the SEC and otherwise you think about the need for greater expertise there?
So I'm not sure I've got a concrete example among the enforcement actions that we have brought in terms of just a board failing to have the sufficient exposure to it. But I think in the cases of either delayed disclosure or inadequate disclosures, like the decision to continue to issue 10Qs and 10Ks talking about a hypothetical risk of a future breach once they know a breach has already occurred. Like, I think that is more sort of a decision-making issue. I think in the rule proposal, which again, I can't talk about in great detail, but there's some discussion of disclosing if you have a board member who has significant experience or expertise in cybersecurity, that's something you should say. If you've delegated that to an executive or an outside contractor, that's something you should say. And I think it is not a requirement that they necessarily do any of those things, but that they provide disclosures to investors, because in an environment where we anticipate that any company could be subject to a cybersecurity intrusion, even if they've invested heavily and worked hard to try and prevent it, then I think it is fair to expect that investors may start making some risk-based pricing decisions where to invest their dollars on those companies that seem best prepared to respond should such an incident occur. And so I think when I think about that provision, that's sort of the direction I'm thinking about it from, is that the disclosures help investors decide how to differentiate between an otherwise undifferentiated mass of companies, which ones seem like they're thinking holistically, thinking strategically about if something happens, how we're going to respond, as well as making sure that they've got people on the board who are thinking about making sure that the lines of communication amongst the executives are open, that the company is positioning itself well to withstand a risk incident.
Well, I see at least on our panel, that Bruce has come back on. Justin, that to me gives you the final say on how you brief boards, and then we'll be able to turn it back to Bruce.
Well, I was going to say that when the SEC regulations if they go into effect and when they go into effect, I'm waiting for my phone to ring off the hook for all these board positions. But I think Arvind's right, that not to over-index on the cybersecurity expertise. I mean, I don't think that means that, you want somebody on your board that was the CEO at Home Depot when they had a large breach. Like, that's not like cybersecurity expertise. And that you should be focusing on like the board as a body itself. And I think one of the things that's important is to train the board into what questions they should be asking about cybersecurity and what their expectations should be for management to provide them briefing about cybersecurity, because that's just as important as having somebody who's got expertise on there. And I would agree with Aravind that you may get more than you bargained for in that situation, which is when you do have an incident, that person's asking a billion questions and diverting from the actual things that you want to achieve in front of the board.
Right.
Very good. Well, thank you very much. I think we could continue for another hour, Bruce, if you give us that. But barring that, I want to thank Dave, Aravind, and Justin for great input. We did prep a lot more material, and there's a lot more we could say, but we'll leave that for another day. And thank everyone for joining us today, and turn it back over to Bruce.
Thank you so much, Justin, Aravind, David. Thank you, and Erez. Thanks for great moderation job there.